Ms. Childers was ordered to pay the sum of $42,506.07 or serve 180 days in Dixon County Sheriff's Office or Sheriff's Department. She has to have the ability to purge herself of this, and there's nothing to show that 3 years later she now does.
It was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. Mr. Claiborne wants the return of the property or his money back.
There's really nothing in the Record to suggest that Ms. Childers still has these items.
But at this time, we're fine with letting her out, but put a few stipulations on it that we've got a reset date.
All right, this is a motion to alter or amend. Mr. Guerin, that's your motion. You may argue it.
That I filed on July 6th of this year. I'm not asking to relitigate the divorce, relitigate the contempt. I'm asking for very straightforward and narrow relief. I'm just asking the court to modify Ms. Childers'.
All right, the rule has been requested. Anyone who's going to be a witness needs to step outside of the courtroom and remain outside of the courtroom until you or yourself are called to testify. You're not to discuss the testimony of any other witness with anyone until you yourself have testified. Now you may proceed.
Thank you, Your Honor. And actually, as it relates to the witnesses, after speaking to Mr. Hawley, the witnesses may not be necessary. I subpoenaed 2 officers to testify that Mr. Claiborne received some of his property back from the police department. I don't think Mr. Hawley is going to dispute that. I believe Mr. Hawley was actually present for that. If we can get a stipulation of that, I can release the officers. The people he subpoenaed, I don't think that anything they'd have to say is relevant to my motion, so I don't think they're necessary either. Most of this is just legal and procedural issues. At the time that this court, back on October 31st, 2023, this court ordered by default divorce favored Mr. Claiborne and also granted the motion for contempt. And that's what I'm asking the court to alter or amend is the order as it relates to the contempt. Ms. Childers was ordered to pay the sum of $42,506.07 or serve 180 days in Dixon County Sheriff's Office or Sheriff's Department. But at the October 31st hearing, Your Honor ruled from the bench, but the final order that Your Honor entered was, at least according to the certificate of service, wasn't sent out until June 4th of 2024. And then Your Honor entered it, I believe, on June 18th, which is well past the 20-day local rule for submitting the order. I've reviewed the file, and if I don't think I'm mistaken, but maybe I am, I did not see any other court dates between that October 31st, 2023 hearing date and the date that Your Honor entered the order. At least based upon my review of the file, I didn't see any motions filed or any pleadings or anything occurring.
My recollection is there were no other court dates, that Mr. Hawley had submitted an order that I didn't agree with the wording of it, and I declined to sign that order and instructed him to redraft the order with what I thought was the appropriate language, and that took some time to do, but that's why it was not. There were no court hearings in between. It was just a matter of me reading the order, disapproving the language that was used in the order, and then asking them to redraft it with the order that I thought was appropriate.
Okay. Well, that order does have a certificate of service on there, and those addresses and email address were not good contact info for Ms. Childers, so she never received the order, despite a few times after the hearing date she called up here, called the clerk's office to get a copy of the order, and she was told every time that you just have to wait on the order to be filed. She only learned of the order after being served with the capias some almost 2 years later. We're now about 3 years out from where the order was filed. And all these items that are listed in the order for her to return, some of the stuff Mr. Claiborne has been reunited with. Ms. But there's really nothing in the record to suggest that Ms. Childers still has these items. There's nothing to suggest that she has this $42,000. I understand it's a civil contempt, but she has to have the ability to purge herself of this, and there's nothing to show that 3 years later that she currently has the ability to purge herself of this contempt. So basically what we're looking at now is basically a debtor's prison. She doesn't have the ability to purge herself, which there's nothing to show that 3 years later she now does. It's become punitive. And because of that, Your Honor, I would ask that the court alter its order or just enter a new order to release her, to show that she's, she's been in jail, 4 months now? The appropriate remedy for Ms. Childers would be to release her from custody. So I'd ask that you grant our motion, modify her sentence to 10 days, and to release her time served from the Dixon County Jail.
Ali, you wish to make an opening statement?
So I remember that we did have some court dates kind of after that October date, Judge. I had put together, and I've given a copy of it to Mr. Guerin. This really is nothing.
You may be correct. This had been, that order was from a hearing in 2024, and as a result, I'm not sure that my memory of it would be as clear.
I've shared this with Mr. Guerin. We talked yesterday, and then I gave him a full copy of my timeline today that's got everything attached to it. I tried to streamline this because this file is rather voluminous and different orders and things flying around. But this is all the orders, the motions, the things that I felt like were important to and germane to our issues here today. You look at the timeline, there was a 2/15, February 15th, 2024 court hearing, and what all led up to that a little bit. And then there's also a June the 4th hearing on the motion to approve the order. And we did have those other two court dates. I had lodged an order with the court. And again, the court had some issues with the order, wanted some amendments. And we had that February 15th hearing, which I sent a notice to Ms. Childers at the two physical addresses and her email that I had. And we had that hearing, and the court instructed me on what to do on the 15th of February. And then there was another change on the 4th of June at our hearing there. And then I submitted an order that the court signed on June the 18th. So this court took special care with this order. The first order I sent in, I did it like I do the civil contempts and whatnot, jailed indefinitely. And the court said, no, you didn't want that. You wanted a provision in there for her to have 6 months of incarceration and to be let out after that. So she was not jailed indefinitely. And there's some other things in there too that this court did that, again, taking careful consideration with the order that you did. Our position today, Judge, is really one of a few things. One, I've filed a response in opposition. If we're going to oppose this, obviously, I think the court, and I can get into the argument on that if the court wants, but I think the court took great care with this order. I don't think there's anything that's inappropriate with this order. If the court will remember, it was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. And the court heard hours of testimony about defecation in drawers of Mr. Claiborne's clothes, urination on the furniture and the beds and things of that nature. There was a lot going on at that time. And Judge, basically, we are asking that, number one, if we're going to go forward with the motion to alter or amend, that be denied. I think the court did what the court was supposed to do with that. Number two, let her out of jail with some stipulations. We're fine with that. If she's here today basically wanting to get out of jail, that's what this motion is about. What we're about today, Mr. Claiborne just wants what's due him, what his justice is out of this order that the court did. Either his stuff back or the money paid, and we've already beat that horse all the way around the track, and there's an order down for that. But we say she's got some time left on her 6 months. Let's stay that, or however the court wants to do it. This is contempt, and the court has the absolute reins, in your hand to do what you want to do here. You're driving this bus. Let her out of jail. Let's reset this maybe to the 1st of December. Give her a little bit of time. to either make some payments, get this stuff back, let her know that this is a serious matter. I don't know if she understood it was this serious, but let her know it is a serious matter. And let's come back in December and see what she's done and it's up to the court then to do what the court wants to do, to see what her conduct was during this period of time. We're not getting any satisfaction here seeing her in jail. Mr. Claiborne wants the return of the property or his money back. And at that time, there was a present sensibility for her to be able to return this property. The court found that. It's in my response. And I'll be glad to go over the response and argue this in detail if we need to. But at this time, we're fine with letting her out. But put a few stipulations on it that we've got a reset date. I may want to file some interrogatories about her. We think maybe she's gotten a settlement, some things like that. We want some sworn answers about that, and either continue this motion to alter, amend until then, or do whatever the court wants to do. But we're fine with that as well. That's, I think, probably the preferred remedy for Mr. Claiborne, to be honest with you. So one of those two is what we're requesting. And again, I'm a little in the dark here as to what we're doing. If we're arguing only the legalities of this, I'd like some more time. If we're calling witnesses, obviously that's up to Mr. Garrett, it's his motion. But if we're calling witnesses, I may call some witnesses, especially Mr. Claiborne, to contradict some of the things. But by and large, if we're going to argue this legally, I'd like to have opportunity basically to argue it legally. But those are, as far as my opening statement goes, that's what it is. Thank you,
Well,
Judge.
this court considers this situation to be similar, if not exactly like a father who has not paid his child support and has accrued a large arrearage of child support under a court order and then fails to comply with that. Then there is a remedy that's given to the court, and that remedy is for civil contempt. The first order that Mr. Hawley, I think, drafted, if my memory serves me, included language that she would either return all of these items or pay him the amount, or she would be incarcerated indefinitely. And I think that was the part that I objected to, because under the law, I can only punish someone by giving them jail for 6 months at a time for civil contempt, but I can do that twice a year, as has been pointed out in child custody cases. But even in the most egregious child custody cases, what happens is you give someone an opportunity to see what it's like to be in jail so that you can hopefully motivate them to come in compliance with the court order. Civil contempt versus criminal contempt. Mr. Guerin makes the argument that this case has transitioned from civil contempt to punitive and therefore criminal contempt, and that's his argument that she's could only be punished by 10 days in jail for criminal contempt. But this court disagrees with that, because under the circumstances, this court heard this case over many, many different court dates, and there was an egregious set of facts in this case. There was a short-term marriage, and sometime shortly after they had married, Mrs. Claiborne got an order of protection against Mr. Claiborne and dispossessed him of his own house, the house that he owned prior to their marriage. The evidence at the trial was that the house, when he left it, had numerous items of personal property that belonged to him and his late wife, and that during the course of the time that he was out of the house, that Mrs. Claiborne had visitors, a number of visitors and parties and things at the house, that the next door neighbor testified that, and took pictures of parties at the hot tub behind the house and different things that were going on like that. So when I ordered her to vacate the house, because it was his home, on a temporary hearing, then she vacated the house. But the testimony was that numerous items, a great number of items were removed or damaged, and that, in fact, what was more convincing to the court than some other things was the fact that there was testimony that the drawers of the dresser in the bedroom had been removed and feces had been smeared on the bottom of those drawers. That indicated to me a malfeasance on the part of Mrs. Claiborne or someone acting on her behalf that justified a finding that she should be required to make Mr. Claiborne whole. The fact is, in most divorce cases of very short marriage, the idea of the court is to hold that parties would be restored to the same position they were in prior to the marriage. Mr. Claiborne owned that house before. He owned all of those properties beforehand, and all of those personal properties beforehand, and that they were missing at the time. We had an extensive hearing where we went through all of the list of items that Mr. Claiborne had that he testified were missing. And the court found that it was justified to hold that she was responsible for their removal while she had possession. It's kind of like what we studied in law school. You know, when you were in possession of someone else's property, you're kind of in bailment of it. And when it goes missing with her situation, obviously she had a number of people there in the house, some of those, you know, not particularly reputable characters. And in fact, I think one of her friends testified against her at the final hearing in this case anyway. So I found that she was responsible for the loss of all of those items of property, and that Mr. Claiborne was entitled to the return of those items, and that she had them or she had destroyed them. And if she had them, she could return them. If she destroyed them, she was liable for the value. I had a hearing. I made a finding as to the valuation of that property, and I ruled that she was responsible for it and that she should make those payments. And she failed to do that, and that's where the order for contempt came in, and I found that she was in willful and deliberate contempt because those items had been removed or damaged. She knew, you know, either where they were or she was responsible for them. And as a result of that, I think it was just that I entered that order. That is no different than if a father or a husband had dissipated assets. Let's say instead of personal property in the home, there was a $50,000 checking account, and one of the spouses had surreptitiously removed that $50,000 checking account. They would be held responsible for that money. And that's the same thing I did in this case. As a result of that, I'm of the opinion that the motion to alter amend that Mr. Guerin has filed, and I've considered it, and his argument that it should be converted to a criminal contempt and 10 days in jail is denied, because I think that I was correct in my ruling initially. But as I have pointed out, you know, even in a case where a father owes substantial amounts of child support, after a period of incarceration, it is usual for the court to give that person an opportunity to be released by suspending the balance of the sentence and then allowing them to be back out on the street, so to speak, trying to find a job and trying to find a way to pay this. This court is of the opinion I was correct in the amount that I set or the items that would be returned. If items have been returned to Mr. Claiborne that since the entry of that order, then those items, the valuation was set forth in the order that was found, and those items, the value of those items would be deducted from the amount that she owes, just like a payment had been made on child support. The remaining balance would be her responsibility, and therefore I find that the appropriate and equitable matter in this matter is not to amend or alter the order, but rather to suspend the balance of her sentence for civil contempt at this time, allow her to be released with the condition that we set a review. I think I'm back here in September, and then again in, when am I back? We'll set it for review in January to determine whether or not she has made any progress in retiring. And I'll be honest with you, if she's making payments towards that satisfaction of that debt, then just like a father in a child support case, I will give her an opportunity to continue doing that. The January the 5th, how about let's make it January the 26th. That'll give her a full period of time. January 26th, we'll set a review date on this case. In the meantime, she is released with the understanding she is going to make progress towards satisfaction of the debt, and then we'll take a look at it at that point in time. Yes.
So one of the issues was her not receiving notice. That was in the motion.
One of the issues was what?
Her not receiving notice of some of this stuff at the end, and I did what I was supposed to do. I did the certificate of service to her 2 physical addresses I had and her email. Can we put in the order that she's required to let the clerk know what her current address would be?
It is the
for mailing
responsibility
purposes?
of all pro se litigants, or if you have an attorney, that she must keep in touch with the clerk's office to give us a valid address. So Mr. Guerin I will put in the order that your client must provide Mr. Holly with her current address. That's fine, as long as the fact is that she's being released, but on a specific review date, then I want to know where she's living, because if she doesn't comply with the court's order, if she just vamooses, then we're going to have to issue a warrant for her. And I'm not going to arrest you. I'm going to send it for her.
Yes, sir.
So I
just need
think the
address.
best thing to do is to just require that she provide you with her current mailing address. Now, when she has that address, the order will provide that Mr. Claiborne is to have no contact with her. In other words, if he doesn't contact her by mail, by phone, or any other means, and she should not contact him. Let's just separate them. They don't need to be together, and I'm making that a ruling. But I do think her address being a part of the court record when she's released is no different than, again, I'm treating this like a father who's been behind in child support, so.
I should make sure I'm doing the right thing and sending it to the right spot. If Mr. Guerin wants to be responsible, I'll be more than happy to send it to him. And just to announce to the court, I may want to file some brief interrogatories about, basically her ability to pay. We think she may have a judgment. There's some other things. So I may want to ask a couple of questions about the receipt of the monies for that judgment. And if we've got items that he's received, I will get with him. I will get with Mr. Guerin. We will attempt to work that out. If we can't, can we reserve that for the review date in January?
That's fine. I think it was Exhibit A that was the listing of the items that you had.
It is, and it's in my timeline. I put that June 18th order in that timeline, and I gave a copy of it to Mr. Guerin today, so if he'll look, you should have Exhibit A in there for his records. Yes. There's a June 18th order in there, and it should have that Exhibit A
I wanted Mr.
attached.
Guerin to be aware of the total amount of the judgment that was entered against her, so that's why. I'm sorry, how much? Okay. 42,000 and some odd dollars, all right. And whatever the value is of the property and all of that valuation is set forth on that Exhibit A, so deduct from that balance what is owed and
Yes, sir.
what the value of that property would be, and we'll go from there.
That's well understood, Judge. We'll do that. And then again, if there's any dispute, we can, if it pleases the court, I can put that to order. We'll just reset that for January.
All right,
Can we reserve attorney's fees and have that at our review date as well?
certainly. Well, we need to have an order signed that would allow it and set it for review. You all can draft even just a simple order that she's to be discharged subject to a review and then supplement that with a more complete order. Then that would be the best way to handle it. So. If you can do it today, I'll sign it today. I saw Lieutenant Martin or Captain Martin or whatever he is, one of your witnesses. You want to bring him in here, we'll tell him what I'm doing, so in case that makes a difference for the jail. I have completely destroyed your files. I don't even know how I did that. All right. Excuse me for blowing my nose. I took it apart, probably. I am ruling that we're going to let Miss Claiborne, I'm going to discharge her from jail today and subject to a review, and there will be an order. It'll take a little bit for them to get a typewritten order, but she's going to be discharged on the civil contempt and be brought back in January for me to review what she's done. So I just want to let you all know so that even if she needs to get out of there, then y'all can let her out by my order to you today, because even if the written order takes a little bit.
Yes, sir.
All right.
Yeah.
Thank you. Y'all are free to go, by the way. You want to let your other witnesses know they're discharged? All right. That'll conclude this hearing.
Thank you, sir.